I think you should lodge a complaint for violation of human rights this afternoon, because having two lectures one after the other immediately is not for a Saturday afternoon. I don't know whether you want me to lecture or just to give you some data on the subject that Professor Reddy asked me to speak, and we exchange afterwards. For you not to get bored too soon. Okay. Well, I'll start with talking about it, but feel free to put questions. I'll give you the main information and considerations I seem important, and we exchange afterwards. Okay. Well, the idea was to talk about women in the inter-American system, women's rights in the inter-American system. At first, a few words on the inter-American system. I don't know whether you have been studying public international law, but okay, better than that. The inter-American system is one of the regional systems that is alluded or referenced. Okay, thank you. It works. It goes? Okay. Is one of the regional systems that is grounded on Article 52 of the UN Charter. That means that this system, which is a system all around the Americas, has as main purpose the maintenance of peace and security. It provides for a regime or a system of peaceful settlement of disputes, but it also takes into consideration the commonalities of the member states, and among those commonalities are human rights. What do I mean by that? Well, states in America, which are largely Latin American states, but there are others, states in America have been former colonies from Spain, Portugal, France, UK, and in fact, as such colonies, they were there when the Enlightenment period took place, and in a certain way they absorbed everything that was considered and put forward at that time, considering human development, civil rights, individual rights, and so forth. So when they decolonized in the mid of the 19th century, their constitutions embodied some provisions dealing with individual rights. When they got together at the OAS, at the Organization of American States, in fact, they went a step forward, and they wanted to have some international coverage of those civil liberties and individual rights. Some landmarks in the development of the inter-American system dealing with human rights and with women's rights. The first one is that, in fact, the OAS was created in 1948, but in fact, that creation was only a sort of blessing from the formal point of view of a gathering of states that started to meet together by the beginning of the 19th century. At the very beginning, it was the risk of an intervention from Europe in America, and afterwards, there were other reasons. But at the end of the day, the American states started gathering here and there, and during one of those gatherings in 1928 in Havana, in Cuba, they decided to set up an Inter-American Commission on Women. That commission is the very first body dealing with women's rights in the world. It's a very special body because, in fact, it's composed by a representative of each of the member states at the OAS, so it has today 34 because Cuba, who had been put outside the system for a while and now has the possibility to be back, has not yet decided when to be back and how to be back. So we have only 34 delegates. Those delegates are meeting every 3 years in a General Assembly, and they have an executive committee that means meets once or twice a year. And the main function of the Inter-American Commission on Women is just policy making. They are supporting member states in the implementation of their duties under international treaties and international recommendations dealing with the status of women. They are supporting member states in their development for the full and equal position of women in society. They are promoting women's leadership. They look for new rules if necessary. Thank you so much. They also promote the further development of the jurisprudence of the system dealing with women's rights and so forth. So, in fact, they are there from 1928, and their main task is just deliberation and policy making. When the OES was created in 1948, the charter of the OES embodied lots of provisions dealing with human rights, and some years after that, it was a sort of common thing by the member states that there was no specific body dealing with human rights. So in one of the meetings of one of the main organs, they decided to create a subsidiary body taking care of human rights as embodied in the charter. That happened in 1959, and they created the Inter-American Commission on Human Rights. That's the same commission that is working today with different scope of action and so forth, but essentially is the same. That commission was composed by 7 persons of high morality and so forth, but at the very beginning, their main task was just putting forward recommendations, drafting reports, and recommending member states what to do in the field of human rights. However, history was not consulted for that function and decided otherwise. And after 6 years, the Inter-American Commission on Human Rights had to change its scope because every constitutional government in Latin America was falling down and replaced by a military dictatorship. So in 1966, the Commission was awarded the capability to handle complaints dealing with the violation of human rights. And because of that, the system decided that the human rights meant those rights embodied in the Declaration of the Rights and Duties of Man. That declaration, and that's the first point on the status of women in the world, Declaration on the Rights and Duties of Man. Okay? Man. They, he, not me. Man. Okay. The point was that at that time they just listed human rights, more or less the same you'll find in the Universal Declaration, but from a completely different perspective. This declaration is a declaration of states that are organized in a republican way, and states that already have some provision dealing with human rights, even though not branded as human rights in their constitutions. So in 1959, the Commission is created. In 1966, the Commission starts with the possibility of handling communication, that is, that adversarial procedure to know what had happened to a victim. In 1970, there is an amendment to the OES Charter, and the Inter-American Commission becomes a main organ of the organization. 10 years later, more or less, the Commission starts to work with a new body, with a new organ, because in 1978, the American Convention on Human Rights, which is the main instrument in the region, entered into force, and the Convention creates an Inter-American Court of Human Rights. The difference between the two organs are important. The court is an organ of the convention, while the commission is an organ of the OES, of the organization. That means that the commission has two hats. The commission is the political advisor of the OES in the field of human rights, and the second hat is that the Commission is in a position to handle communications alleging human rights violations, and it has the possibility, after an adversarial procedure, to say whether it finds or not a violation in the given communication. The court itself is there, as all international courts, you know, has a non-binding jurisdiction, so you have to accept the jurisdiction, and it produces rulings for those cases that are brought to it once the Commission has already worked, and it also produces advisory opinions on certain aspects of the system. So, starting 1978, the two organs are there, and in fact they work sometimes one after the other, sometimes only one of them, in different fields in human rights, and we have their production as an important output for the situation of human rights in the region, and also for the situation of women's rights. Second set of considerations relating to women's rights. Perhaps you have already been told that, in fact, the drafting period of the UN Charter and the OAS Charter itself is a period in which women who had already been organized from very long before that, women started to organize themselves at the Enlightenment period, when the first of them realized that the declaration, the French Declaration of the Rights of, I'm translating from French, Declaration of the Rights of Men and Citizens was only deemed to be enforced towards men. Women started to gather and to think what to do with their rights. That's the very first moment of feminism in the world. But coming to our time, to the time of the drafting of the two charters, OAS and UN, that was a period in which women were very strong claiming their political rights. Why? Because during the war, they had to leave their homes and to take some positions that had previously been held by men at the post office, communications. There was a time in which these sort of phones didn't exist, and you needed someone to give you the opportunity to have a communication. They were just performing different jobs that had previously been performed by men. So when the war was over and they were told to be back to their kitchen baking cakes, they decided that they could bake cakes, but also wanted to do something else. And this something else started by the claim of having political rights. Something very basic. I want to keep my maiden name together with my husband's name. I don't want to change my nationality because I'm married. I want to have the right to vote, to be a citizen, and to have the possibility of choosing and electing our authorities. So at that time, sex became a very important indicator in these human rights instruments. This consideration is just to let you know that the struggle of women for their rights started well before the notion of human rights was crystallized in the international arena in the 40s. What's special with the rights of women in the inter-American system? Well, the first point is that the system decided very wisely, in my opinion, to have a very comprehensive set of rules dealing with our rights. So, together with the American Convention on Human Rights, the system decided to add the CEDAW Convention, the Universal Convention dealing with the elimination of discrimination against women, and we added another instrument, regional itself, dealing with the violence against women, the Convention of Belém do Pará. So this idea of having an only corpus juris, as it says the court, with the three instruments is important because it makes easier the task in the system that lacks a comprehensive text dealing with women's rights to make an interpretation of the rights of women in the light of CEDAW Convention. And at the same time, the Belém do Pará Convention, which is rather special because it's a very comprehensive set of rules struggling against violence, provides some elements that CEDAW itself will take afterwards in order to enrich its own case law. So what about, 2 words about the 2 conventions. CEDAW is the more important instrument dealing with women's rights. And CEDAW is the instrument that makes the women's rights become women's human rights. So we start saying, which is obvious, that women's rights are human rights. And that's a sort of important submission, because at the very beginning, human rights instruments had a main trend to universality, and that main trend was expressed through the use of certain neutral nouns like person, every person, all, no one, nobody. And of course, for those that were drafting, perhaps we were included in every person, in none, in nobody, or in all. But the other half of the world didn't agree with that. So the convention that CEDAW makes is that when it says, okay, women's rights are human rights, it starts reciting human rights, but using a subject, women. So we start saying what is obvious: women have right to life, women have right to integrity, women have right to freedom of expression, freedom of religion, whatever. So everything is declined, taking care of women. At the same time, CEDAW has this important tool that are the transitional special measures that make a difference with formal equality. These measures allow to bridge the gap between what the situation is and what it should be. And this is important too. And in many countries, especially in our region, for instance, from the point of view of political rights, have been very useful. The percentage of women in Parliament, for instance, in Latin America, in America in general, but I say Latin America because the US and Canada are not in the first places there, has increased a lot because of these special temporary special measures. On the other side, you have the Belém do Pará Convention, which is important because it deals with physical, psychological, and sexual violence against women, either at home or in the family unit, performed by other private actors, and also performed by civil officials, by public officials. So this is a convention that, again, makes a difference with others because it introduces the possibility of private actors to commit certain or sometimes crimes, but not always crimes from a strict legal point of view, that amount to a human rights violation. CEDAW Convention has also a very important cultural scope. One of its provisions deals with the possibility of changing the culture in a given society so as to transform this patriarchal relationship in the society, trying to exclude stereotypes and things like that. So CEDAW is important from a very basic point of view when dealing with human rights. And that very basic, but all the more important point of view is the cultural approach of human rights. Once we include human rights as a part of our culture, we are a step forward. We are not only honoring human rights because we are under the duty to do so, but because we are persuaded we have to do so. And that's important. And the CEDAW committee is also a sort of crystallizing point in which women, because there are nearly no men there, they don't apply to be members of the committee. Women try to melt all their different points of view because they come from different cultures, from different civilizations, and they make a sort of synthesis of what women in the world deem necessary in a certain and given field or subject in the light of their rights. So that's the very first. I can go over some of the special features of different subjects, but I want to listen to you first. The system itself speaks through the legal rules, through the recommendations, legal rules through the treaties, through the recommendations, but also through the different judgments the court produces and advisory opinions, and the case law produced by the Commission, the Inter-American Commission, and also the reports on the situation of given countries drafted by the Commission. Some of those reports are very eloquent on the situation of women and how women sometimes are the victims not only of this male-women relationship, male-female relationship, but also they are victims of armed conflicts. The violence against women is a part of a strategy in armed conflicts and so forth. So I'll take a breath, I'll have some water, and I'm listening to you. I can go over, but I don't want to. No doubts? Everything is clear? Yeah. Try to speak slowly, because English is not my first language, and loudly. Okay, let's start by the very first one. It was the situation of women in which context? Okay. Well, that's a question for someone doing political science and not law. But to my knowledge, I have been living in Latin America for the whole period in which insurgents and armed conflict has been there. My feeling, I have not the evidence to be provided to you right now, my feeling is that women in general have not been prominent in the leadership of the armed groups that took place in the armed conflicts. However, because of the armed conflicts, women have been prominent in the struggle for memory, for truth, for justice, and also in the struggle of their rights. One of the main examples I can give you, and I know that because I've been the special rapporteur for the situation of the human rights in Guatemala at that period, is the situation of widows in Guatemala. The civil war they had nearly killed all men of the Mayan society. Mayan society is a very large world, because there are at least 23 different Mayan communities, each one with its language, what we were talking a moment ago. And in fact, they all speak a little bit of Spanish in order to communicate among them. And widows in Guatemala organized themselves. They have a sort of coordination of widows in Guatemala, and they started claiming for those that had disappeared, for those who had been killed, for those that were in prison, and after that they started being harassed by the government. And arrest was through usual means, threats and things like that. But one day those usual means turned to be special means focusing on their quality of women. So they started raping them. For instance, they were in a bus, they stopped the bus, everybody was down of the bus, they took the women in the bus, they raped them, they asked all the others to come on the bus, and the bus went on like that, as if nothing has happened. And when they became personally in their bodies victims, it was extremely difficult for them to move forward with a claim. They had faced the most important dictators of the country because they wanted to know the truth, they wanted justice, they wanted something different for their kids. But when they began being raped themselves, well, something was completely different. And they needed a lot of support in order to put forward their claims. That was a mix. That was a mix of the prevailing culture. That was a mix of the situation of women in a society, in a community in which rape is something treacherous. If ever you are raped, you never can rebuild the social ties you had before. So, and this is, I'm just speaking to you about the widows in Guatemala, but I could say the same of the women that had been raped in Yugoslavia, in former Yugoslavia, and countries like that. So that's what happens. At the same time, when the peace process starts, women are those that are the most, not rigid, but they are very serious in their claims. They know what they want, and they just try to put forward and say, okay, what you are negotiating there will be got in 2 minutes, but that's useless. We need something more. We need to move a step forward. And they're very important in the negotiation of the peace process because of their claims and because of the requests they put forward in order to try to rebuild a different society on different bases. Which was the second? I'm getting older. The enforced pregnancy, was that? No. That's a big question. If ever I had a good response, I wouldn't be here right now. That was, you were referring to the, but the case is dealt with by the Inter-American Court. Okay. The cases on enforced disappearances in the inter-American system got in many, many years after those disappearances took place. Those are the big cases dealing with massacres and things like that. And those are massacres that took place mainly in the first years of the 80s, or the court was already there, but in fact those countries were not part of the statute of the court. So the court got to know those cases some 20 years after that, or more or less. In those cases, in the great majority of the cases of the enforced disappearances, because every country has different features for the enforced disappearances. But for instance, Hellman is a case against Uruguay, is a case of a girl that was disappeared. Well, in fact, she was given birth during the enforced disappearances of her mother, and the mother was taken from Argentina to Uruguay. She gave birth in Uruguay, and the girl was given to a family, and she was killed, of course. And her husband had been previously killed. When the court has to deal with that situation, the court had a new approach that was not in the previous rulings dealing with enforced disappearances. But that happened also at the level of national courts. In my country, in which after dictatorship we had a very big national trial in which all the former military commanders of the country, including 3 de facto presidents, were tried, the court lacked any gender approach. They only said, okay, she was taken there, she was raped, but at the end of the day we ignored where she is. That was the same pattern for everybody, except that when they were dealing with women, they said that they were raped because someone else had given witness of that in the trial in the court. So that lack of gender approach at the very beginning was superseded nowadays, some 10 years ago, more or less, with this new inclination of the tribunals to make some considerations on the gender of the victim. And when dealing with the gender of the victim, they deal, I'm not very fond of Hellman, but of the ruling in Hellman case. But in any case, they do that in a way in which is very basic, as you say, women against men. And perhaps it's not the proper way of doing that. It's true that the court has been lacking women for a while. That does not mean that you men cannot have a gender approach. Sometimes you have a better gender approach than women, because being a woman is not any guarantee of having a gender approach. That's something that you have to learn, because gender issues are cultural issues, so you have to be educated with the gender approach, and that's the way of having it. But that was not a very good approach, because it's like putting women on the one side and men on the other. I don't know how to do it or how to deal with it properly. My feeling in cases like Hellman and others of the Inter-American Court is that the court was too much structured in the way national courts work. And in some of those countries, what is important when dealing with an enforced disappearance is, okay, either you say this is a crime against humanity and you send the perpetrator to jail for his life, either you shut up and you put in place some ad interim solution. But in fact, what we need is to try to enforce this gender approach throughout everything. And of course, when dealing with armed conflicts or with conflicts, if they had a recognized situation of armed conflict, of no, it's useless at this point in time. The question was that there were some people having all the possibilities in a country to make some people disappear. And when doing that, they could prevail themselves of whatever they wanted. And there the most ancient tools of war came into being, and rape is one of them. In other armed conflicts, and that was one of the points I wanted to raise afterwards, in other armed conflicts, for instance, in the armed conflict in Colombia, the one that has been reached peace agreement some months ago, and they're just trying to put in place something very difficult, very complex, and so forth. The Commission dealt with violence against women, and it focused on the role that violence against women played for the conflict, having the conflict as an object. And the Commission said that first, women were abused and violence was perpetrated against them because they wanted to destroy the social ties. They wanted to hurt not only the woman that they had in front of them primarily, but also the big circle around that woman, the family, the friends. So they wanted to impose some sort of terror in the community, and that was also a way of monitoring the territory. You have families that are frightened, you have raped women, and they are still there. If they are still there, that's a territory that you can manage in an easier way than other territories, because people won't put any resistance against the prevailing methods. Second, sometimes those women are the victims of violence because it's a way of recruiting women for these movements. They need some sexual activities, and so they recruit women, and they have them working for them, either within the group or outside the group. But in fact, they are recruited, and they are recruited primarily for their sexual services, not for being a fighter, freedom fighter, as the others may be. And the third one is sometimes they exercise violence against women, and they force women to move from that region to another one, and the situation of the woman that has to leave the home, the family, and the social environment where she was, and moves to some place, she takes with her this situation of fear of being followed and monitored. So you have a sort of terrorized population that you can control easily at the same time. So this is not only the very traditional say, okay, there is a man, there is a woman, there should be some sexual appetite there, and you need to pay a sexual service. There are other ends that are pursued with women. And of course, the situation of women having been educated as those providing care, those being in charge of, that makes you to feel twice at fault, as if you had yourself being looking for that to happen. And this is not because you are not reasoning well. This is because there is a prevailing view in the society according to which every time there is a sexual crime, instead of looking for who could have been the perpetrator, the first reaction is, what was she doing? How was she dressing? How was her behavior? So the first reaction is to turn the victim into the one who has provoked the crime to be committed. I don't know if that's enough, but there are some ideas around that. Yes. I think, to my knowledge, rape was is among the war crimes, at least in the Rome Statute, and it may be also within the crimes against humanity, because it can be itself and also as a means to commit genocide, because you are changing the population. So what seems to me interesting is that especially the tribunal, the ICTY, the tribunal against, the criminal tribunal for the former Yugoslavia, dealt with that, and it did so on the grounds of what had already been put forward by the Special Rapporteur on Torture, by the Inter-American System, and I don't think because of the European system, but because I think there was nothing at that time in the European system dealing with rapes and with armed conflicts. But the story of enforced disappearances and so forth started by late the 90s with the Turkish cases, but not before that. So I think one of the great successes of this international criminal law was to take into consideration that there are some crimes that are perpetrated to women and that this deserves special consideration. It's true that till now what the tribunals have been doing is considering each individual case in itself, and so you need to have the evidence for Miss A, Miss B, Miss C, and Miss D. And it would have been perhaps more useful to have a sort of test that could amount to produce evidence on the practice, systematic practice of rape as a method in a given context. I think it was not like that, because even though the provisions of the Rome Statute are very progressive in the sense that they included what hadn't been included till that time, those that were asked to enforce the Rome Statute were not necessarily as progressive as the Rome Statute. So they came with their own background and national background, and it was difficult sometimes to make the difference on that. I do remember one of the judges, I won't tell you the name, who told me, for that case it was great that Judge Mumba was there. Judge Mumba was a woman, because we wanted her to head the case. Okay. It's the same. What we need is people that is gender sensitive and not necessarily a woman. One of the best cases to illustrate why a woman by herself, by definition, is not necessarily gender sensitive is one of the cases of CEDAW, the case of CARI Invertido, a woman in Philippines, who's, you know the case? She was a woman that at 60, not before that, at 60 she was raped. And she was raped by the president and the CEO of a commerce chamber where she worked. And everything that is a stereotype happened in that case. Nobody heard when she cried. Nobody saw her. And when some of the witnesses were called to the tribunal, they said, but I think they were flirting because she looked like liking him. And she had the bad luck of having a woman as president of her tribunal. And the woman has the remark that she stressed more than once in the ruling, saying, it is very easy to accuse someone of rape. It is very difficult to prove that the rape is there. So she did everything for her to become the one who provoked, the one who was just asking to be raped and things like that. So that ruling was brought to the CEDAW committee, and the CEDAW had some very important expressions for the government of Philippines in the way in which it had to ensure that the respect for gender issues. And one of those considerations was exactly that one. You need to have judges trained in gender issues, which is not exactly the same as saying you need to have women judges in all rape cases. You have to speak loudly because... Okay. The Inter-American Court is as open as the Inter-American system itself. You have to know that the system obeys a little bit to the features of the culture and of the countries of the region, because the system itself has suffered more than one amendment, and those amendments were not embodied in the American Convention, but came through the regulations. So the rules for the Commission, the rules for the Court have changed a lot the way in which the Inter-American system works. One short example, because of the amendments in the rules of the Court, now you have the state, the Commission, and the victim. But the victim itself is not provided for in order to be a party to the procedure in the Convention. However, the rules decided that at least the victim should be there in order to provide his or her or their point of view to the court. So the court takes sometimes some of the jurisprudence of other courts, European courts sometimes, even though in certain central aspects both jurisprudences are openly different. We have the fourth instance, they have the margin of appreciation, and the way in which both systems, the European and the Inter-American, focus this point is completely different. Sometimes what the court has is to take something that has been produced by another body outside the system when it deems that the system, that the state parties of the Inter-American system are also parties to the other system. For instance, sometimes trying to enforce economic, social, and cultural rights, the court brought some dicta by the Committee on Economic, Social, and Cultural Rights of the Covenant, of the 1966 Covenant. And that was on the ground. It said something like, I don't need to go further in this point because the Committee on Economic, Social, and Cultural Rights has already established that, and all the state parties in this case are parties to the covenant. So this is a sort of binding, not binding, but jurisprudence that has to be taken consideration of. It has done more or less the same in the case of CEDAW, in the case of the Convention on the Rights of the Child, in the case of the street children in Guatemala too. In those cases, the use of the universal text was with the view of having criteria for the interpretation of very short and concise stipulations of the inter-American system. For instance, every child has right to the protection that he or she deserves according to his or her age. So that means all, that means nothing. You need something in order to put that in practice. And they decided to put that in practice in the light of the convention, the University Convention. So the use of these sort of standards depends very much on the moods of the court. But I would say that one of the first, perhaps, inferences is that, as it happens many times, inter-American states are also parties to another instrument, and so they take what the treaty body has said about a given subject. And coming to the European Court, at the very beginning, they used many standards of the European Court, but lately they changed them. I had to work in one of the cases, one of the first cases in which the court faced a victim that was alive, because the first cases were all victims that were dead or disappeared. And I had to work in a case in which the victim was alive. And the point was that he was claiming that his detention was arbitrary. And the point was that in order to get the conclusion on the arbitrariness of his detention, he started counting the days he was in prison, but he didn't make any distinction on the different legal situations that brought him to prison. And at that time we had nothing in the system, so we had to look somewhere else. And the European system had some criteria on that, saying, okay, detention cannot be said a complete set of years, months, or days. It depends very much on the file, blah, 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 and many, many criteria. We put that forward, that worked, and for the first rulings, they decided according to that set of criteria of the European Court. After that, after a while, they started changing that, and they moved on the grounds of decisions that had already been made by the Commission and by the court itself. Yeah.
So in a lot of instances, but specifically in Asia, we see that cultural liberalism is used against these things. So for example, in India, we recently
Criminalizing?
It's where it's a custom in the
Talak? Yeah, I know that. 3 times and you are out.
Yes.
I know that, yeah.
So you have a judgment which says that because talak is not a part of the Sharia law. Right? And in some instances where the burden of proof emerged in the case of women's rights or communities against communities where they are women, it was reversed through various amendments in India, something which is just the reverse of the original rule, which is presumption of innocence. Becomes something that the victim does not have So cultural criticism is more often characterized against so do you think, my question is this, that do you think that in cases where there is a historic exploitation or violence against a particular community, cultural criticism is something which will not be considered as a theoretical framework in human rights discourse, rather than a universal, and it is considered that by virtue of the fact that somebody is a woman, she should have certain absolute rights which will not be
That's a difficult question because I'm not coming from the Middle East nor from India, so in fact, there are differences in the education and the culture we are performing. The point to me is that relativity or cultural relativism have been widely invoked by those who pretended to cover human rights violations. If you put that aside and you try to explain why cultural relativism exists, there may be some good reasons to deal with it. And there may be good reasons because, of course, each of us sees the world and the relations that take place in the world from the culture in which he or she is or has been educated or he or she is living. So there are differences. Even the notion of human rights itself, when the notion of human rights comes into being, the revolutionary note is equality. Because you can find protection of dignity in many parts of the world for many people. Not for all, but for many. You can find protection of freedom in many parts of the world for many people. Not for all, but for many. But what you can't find is protection of dignity and freedom for all on an equal footing. And that's the revolutionary note. But the revolutionary note is not even to say on an equal footing. It's to say we acknowledge that we are born all different because every woman is unique, because of economic conditions, because of health conditions, because of weather conditions. There are thousands of conditions that makes that two pregnant women give birth to two different creatures. So the point is that we are different one from the other from the very first moment of our lives. What is interesting of the notion of human rights is that it takes advantage of law and uses the legal tool to say, okay, from now on, in order to be subjects of human rights, we are all on an equal footing. And there is no ground on which discrimination can be valid. So that's the first point. And that equality, at the very beginning, perhaps it was assumed to be only a male equality. But after that, you'll have equality claimed by women. You have children claiming to be heard. Why do I have to stay with my PAM if I want to go with my mom? Or why I do have to stay with my mom if I find that my dad is better with me, I have a better relationship, and things like that. And after that, you have the claim of thousands of others. So the point of universality is not uniformity. Universality is like making difference legitimate. But in order to make differences legitimate, you have to respect a certain ground. And the ground is not to be defined by Mónica Pinto, who was born in Argentina and who lives in Argentina and works in Argentina. The point of whether the cultural relativism is hurting women's rights in the Middle East is to be decided by women in the Middle East. We have to help. We have to help. But there is no possibility of coming from outside and saying, you guys, you are not doing things as you should. Because you lack legitimation in order to do so. So you need the feeling of the people in the situation. And to my experience, I'm very much privileged because I've had the possibility of practicing human rights in the field many times and in many different countries of the world, not only in Latin America. I guess that the situation of being in violation of human rights is something that is felt by everyone, even though lacking education. You don't need to be in a law school to say, I'm a victim of a human rights violation. Perhaps being in a law school, you may say, which is the article that has been breached. But when you face someone who has no education, no formal education at all, and says you, listen, madam, this situation that is happening to me is unjust. And you know that the situation is that she has been raped, that she was forced to marry someone who's older than her, that she was forced to do or has a forced pregnancy or things like that, or that she's not allowed to get into education. You come to the conclusion that this unjust means I'm the victim of a human rights violation. And it happens a lot, and it happens in these societies too. And I think that there is some solidarity of the international movement of women, but at the same time, I think that in situations like that, the existence of a body, of a treaty body like CEDAW is very useful, because in CEDAW you have women from all over the world. And women coming from Middle East societies, from other societies that don't make enough room to the situation of women and to the rights and freedom and dignity of women, they know what they are talking about. And when they come to a consensus with their colleagues in CEDAW, what they are doing is just providing the world with the language of arguments that is important. We know that religious feelings and cultural feelings may be strong enough for women to be prevented from doing something. And I can come with this, bring in an example of the society where I'm living. The great majority of American societies are either Christian or the great majority is Christian, Catholic or Protestant. But for the Catholic Church, abortion is not permitted. And of course, every time you want to move a step forward in abortion, you face the resistance of the church and of those women that have a serious religious practice. And the point is to say, okay, if you are not living in a religious state, you are not obliged to practice abortion. You may decide you don't want to practice abortion if you are in the situation because your religious feelings are stronger than the situation you are experiencing. The point is that human rights are not there in order to get rid of all the religions in the world. Human rights are there in order for us, for human beings, to have a better quality of life. And I haven't found any evidence in this world that persuades me that people can have a high quality of life having women as second-class citizens or not even as citizens. So the point is that, and I'm not very traditional in this view, the point is that to me, cultural relativism is important because there are particularities of culture in different parts of the world. And we have to take note of that, and we have to work on that. The point is that every time you hear to cultural relativism is because you have a dictator there or a man with all the powers of the nation saying, this is the world, we do things in this part of the world, and you have no say in this situation. That's not the way in which things have to be done. And of course, when we started with this movement of human rights, there were many countries that didn't exist in the world. India was not there. It was in 1948 that India was there. And the drafting of the charter with sort of putting forward the elements of human rights was in the 40s, early 40s. But afterwards, the great majority of them endorsed that. So the point is to try to accommodate in order to have that in place in a decent manner, in a manner in which the women in each society can afford it. And coming to talaq, when you refer to that, I always remember that many, many years ago, more than 15, I read that women in the Indian society, Muslim women in the Indian society, just performed mass demonstration against the practice of talaq. and they seated in a park, and they just got this part, I don't know how it's named, of their dressing. And the claim was, we are not against talaq. What we want is to have talaq practiced in the way it should be, and not in the way it is right now, because they come to us and they say 3 times, talaq, 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 you go home, ciao. So for me, that was a great expression of how things can be done. So I wouldn't accept talaq, because I have been educated in a completely different culture. But if women in the region say, okay, we are not against that, but what we want is that you, male, pay attention and do that in the way you should, well, that's something important. That's something important. That's why I think that in order for these human rights to be universal, you have to take into consideration differences, and you have to legitimate those differences. And the legitimation process is very complex. It's very complex. And there are situations in which traditions perhaps are going to be set aside, because the major feeling of the women in the region is not compatible with those practices. And that happens. You have more than one example, more than one example. There was a woman in Pakistan, I guess, Hargul, that was forced to marry a man that was 45 years elder than her. She gave birth to I don't know how many children, and afterwards she was put in a room, and the room was locked, and she was not given any food. She spent there I don't know how many months, and one day she was discovered because someone that passed that street listened to some noise, always. And so he went to the police came, and she was discovered there. She was nearly dead. And when she got out of there, the first words she had is, I want to tell what happened to me because I don't want any other to suffer what I suffered. So I think perhaps the mass media put some words in her mouth, but in fact what she said was substantively that. So the situation of being subjugated, the situation to be exploited, the situation to be not as equal as the other equals, is a very difficult situation to be lived, to be experienced. And I think that when women all over the world say, we don't want that, basta, that should be paid enough attention. No, I thank you for your questions, but you know more of the system, inter-American system, of what I thought. Okay, it's great. I will tell our colleagues in the inter-American system that they are read by you. No, yeah, of course, of course. Thank you very much, and thank you for coming here Saturday afternoon. Like forced labor.